Hello and welcome to this webinar summary of our 14th annual Employment Law Breakfast Briefing. My name is Ian McRae. I'm a partner here in the employment team at Field Seymour Parks, and I am going to be taking you through some of the changes that are due to employment law in this year, 2026, and also some that are due to come in 2027. I should say I am recording this in January of 2026. So if you are watching this sometime after it has been recorded, just be a little bit careful that things haven't changed between the time of the recording and the time that you are watching it. So just briefly introduce the firm for those of you who are new to us. We are about 140 strong firm here in the centre of Reading, and we are a full service legal firm. So we don't just do employment and immigration law, we cover a full range of commercial services, as well as private client services as well. So services for individuals, whether that's residential property, wills, trusts and estates, or family and matrimonial work. We have got all the normal recognitions you'd expect of a reputable firm. And we pride ourselves on providing practical, tailored advice for our clients. So I will try and live up to that in today's webinar. So a quick summary of the things we're going to try and cover today. Most of these changes are due to the Employment Rights Act that was passed in towards the end of last year, 2025, passed in December. But there are a few other areas that we will cover off as well. So main areas, we'll start with looking at unfair dismissal, which is the area that's got the most publicity. We'll then look at redundancy and some changes that are coming in that impact fire and rehire, or how you change employment terms mid-employment. There's some leave changes I'll summarise, changes to harassment and discrimination. And we've also got, looking ahead in particular to 2027, some changes that are due for 0 and low hour and shift workers, changes to trade union legislation, right to work checks, and some enforcement changes as well. So a fair bit to get through. So let's start with the biggie, the one that's been getting the most publicity, which is the changes that are due to unfair dismissal. So for the current position, for those of you who aren't familiar with it, if as an employee you want to bring an unfair dismissal claim, you generally speaking need 2 years service with your employer, unless you can establish that it is an automatically unfair dismissal, which is things like where the dismissal is linked to whistleblowing or health and safety issues. There is also a cap on what's called the compensatory award for unfair dismissal. So the main value of an unfair dismissal claim for most employees is the loss of earnings and loss of financial benefits they suffer as a result of losing their job. But there is a cap on the maximum value of that sort of financial losses, which is the lesser of £118,223 or 52 weeks sort of actual pay, whichever is the lower of the two. So as many of you will know, the government previously planned to change unfair dismissal to a day one right, and they weren't proposing at that time to make any changes to that cap. So the idea of that was that you would qualify for unfair dismissal protection from day one of your employment, but there would be what was called a statutory probationary period, likely to probably be 9 months, where there was going to be sort of a light touch process employers could follow to dismiss employees during that time. I'm not going to talk about that anymore because that all essentially went into dusty bin. And in November of last year, the government changed tact. And instead of those proposals, they are moving to a position where the qualifying period for unfair dismissal will be reduced to 6 months. And those financial caps on the compensatory award, so the £118,223 or the lower of 52 weeks pages, both of those caps are going to be removed. So you will qualify for full unfair dismissal rights from 6 months, and you will also be able to bring a claim potentially with an uncapped value. And we are anticipating those changes coming in on 1st of January 2027. At the time of recording, that is when the government is saying the qualifying period will reduce. We are assuming that the cap change will also take place at the same time, but that isn't yet confirmed as of today. So What's the impact of this going to be? Well, the government in January published their sort of economic analysis of what they thought the impact would be of these changes. They estimate that it's going to extend unfair dismissal protection to 6.3 million employees, so not a small number, and that will result in 9,000 more referrals to the ACAS Early Conciliation Service, which is the process employees have to go through in some form or another before they issue tribunal proceedings. That then resulted in 3,000 extra tribunal claims and then around 570 further hearings. That increase of 3,000 employment tribunal claims, just to give you some idea, that's about a 12% increase. But I should say we have seen over the past year an increase in litigation anyway. So the last set of annual figures, sort of single claims, went up by 23%. So you're looking at a rise in sort of level of litigation, and this is gonna take it up a further level on top. Who's going to be most impacted? Well, all employers, ultimately, or any that have employees over 6 months service, I guess. The biggest impact likely to be on smaller businesses where maybe their probationary period processes aren't quite so robust. Those recruitment processes aren't quite as stringent. And they also probably have less HR support internally. Also, those sectors where the workers tend to have relatively short service may be more impacted than this. If all of your employees already have over 2 years service, then the impact's going to be nominal. But yes, it's those sectors, maybe like healthcare, retail, hospitality, that may see the biggest impact. The removal of the cap, so this is slightly unusual. Most of mainland Europe has some form of cap on their equivalent of unfair dismissal. What the government has said in their analysis is the exact impact of it is slightly unknown, basically because of the behavioural response is uncertain, is the wording they've used. But if we look at the obvious impacts, it's those people who've got high value claims. So senior executives, those who are earning more than £118,000 a year, those who might be entitled in future to substantial bonuses or maybe equity in a company, that's going to have a big impact because suddenly the value of those claims could increase dramatically. Professional footballers, you could probably add to that list as well, or at least those at the top level. And those who are suffering long-term loss of earnings, so those people for whatever reason who might not be earning huge amounts, but are likely to suffer, multiple years or career loss of earnings. Again, this could dramatically increase the value of their claims. And we expect it will have some impact on sort of settlement discussions because the determined window for settlement is going to broaden. Previously, you always had an upper end on it if it was just a normal unfair dismissal claim. That's going to change because you've got that no cap on the top end. One of the things that is suggested that it might reduce discrimination claims. So a lot of employees will bring discrimination claims currently, or will be encouraged to bring discrimination claims because they haven't got the length of service for an unfair dismissal claim, and because those claims have an uncapped value. With the reduction in the qualifying period for unfair dismissal and the removal of the caps, the incentive to find a sort of discrimination angle for your claim might be reduced. That might reduce discrimination claims, might reduce the complexity of claims that tribunals have to consider. One other thing before we sort of move away from unfair dismissal is some of you may be aware that there is sort of enhanced protections currently in redundancy situations after certain family-friendly rights, most commonly sort of during and after pregnancy or maternity leave. In the Employment Rights Act, the government is granted an enhanced, wider power to extend that protection to other dismissals after certain forms of family leaves, and not just in redundancy situations. We don't know fully how the government will intend to use that power, save that they have said that they want to introduce further protections in the 6-month period after maternity leave, where it will be automatically unfair to dismiss someone except in specific circumstances. Devil in the detail a bit there. We don't yet know what those specific circumstances are. But you just need to be aware that that protection that we might be quite used to in redundancy situations could potentially apply to, performance or misconduct dismissals as well, or a similar protection anyway. That change is probably not due until 2027. Right, moving away from unfair dismissal slightly, but sticking with an unpleasant topic, I guess, in a way, and dealing with redundancies. So, in very simple terms, there is a current test that if you are proposing 20 or more redundancies at a single establishment in 90 days or less, you have to follow a collective consultation process. And that essentially is an enhanced level of consultation. It's normally done or should be done via employee representatives or via a recognised trade union. Um, and what the government was originally proposing on this, if anyone was listening to last year's recording, was that they were going to remove that establishment test entirely. So you would just look at how many redundancies were proposed across the entire organisation. They've moved away from that, but what they are planning to do is introduce an additional threshold. So you'll still have the threshold I've outlined, that sort of establishment test. But they also say if you reach the threshold number of employees across your business, so if you are proposing a certain number across your entire business, then that would also trigger collective consultation. Now, we don't know whether that will be a number or a percentage. So it could be, for example, 100 employees across your entire business would trigger collective consultation. Or it could be that if you're proposing redundancies that would lead to a reduction of 5% of your workforce. We don't know. We wait to hear. But the idea is if you meet either threshold, you'd have to carry out a collective consultation process. That will be for 30 days, unless you've got 100 plus employee redundancy proposed at a single establishment. So using the traditional test, and that would be a 45-day consultation. There's some accompanying changes with that. There's some changes to the information that's required to be provided to representatives, particularly around the establishments where redundancies are planned. You don't have to consult all the representatives together, and you can potentially reach different outcomes for different sites. Those changes are likely due in 2027. A couple of other things before we move away from redundancies. Just highlighting a case from 2025, which is to do with how you count the number of redundancies that you have planned. There was a European Court of Justice decision, which I've named on the slide there, that brought some uncertainty in. This micro focus case appears to indicate that you can, broadly speaking, discount those that are already dismissed. So it's a forward-facing look. How many am I proposing in the next 90-day period? You don't have to look back necessarily at those that already have been dismissed. We still await a bit of clarity on whether you count those that are sort of already in process, or you've told them they're redundant but they're working out notice. For current purposes, I would recommend that you include those in your numbers when working out whether you've got a collective consultation obligation. But if in doubt, obviously take advice. Other thing to highlight is the award for failing to comply with this. The protective award is doubling from April 2026. So that is coming in soon, doubling from 90 days to 180 days pay for each worker. And a reminder that that is a sort of punitive test. So a tribunal will normally start at the maximum award and then only reduce it down if if you can show that you've taken some steps towards complying with your obligations. And there's also a risk of an uplift if you've failed to comply with the relevant code of practice. What are your actions on this? Well, we need to know what that specified threshold is going to be across entire businesses, but ultimately you need to track your redundancies across the entire business in a way that you may not have done so to date, particularly thinking about short service employees, where often reasons for leaving aren't fully tracked. And larger employers may be more attractive to having standing representatives in place, so they are ready as and when they have a collective consultation process. They can just go rather than having to run sort of an election process. Right, moving on, fire and rehire. So without getting into all the details of how you can change employees' terms and conditions during their employment, very broadly speaking, there are two ways you can do it. One is that you get their consent to it. So that could be their express consent. You get them to sign up to a revised contract. It could be implied consent, i.e. where you make the change and hope by the fact they don't complain about it and don't resign and bring a claim against you that they have implicitly accepted it. Or you run a process that is commonly referred to as fire and rehire, which is in simple terms a process where you propose a change to your employees, you follow a consultation process with them, you explain the necessity for the change, you listen to their concerns with it, you try to reach an agreement, but if you don't, you reach a stage where you terminate their employment, but you immediately offer them re-engagement on the revised terms. Now, we've got changes due to that process that is going to make it even more difficult than it is now. I wouldn't say it was an easy process currently. These are likely due in October 2026. And what these changes are, in simple terms, going to say is that dismissals will be automatically unfair if the reason or principal reason for that termination is that the employee didn't agree to a restricted variation, that you are employing somebody else with the same or similar duties, and there's a difference in terms between that new employee and the outgoing employee that is a restricted variation, and also in circumstances where you are replacing an employee with a non-employee. So most commonly or simply maybe a self-employed contractor. There's a few different things there that we need to dig into. So firstly, what is a restricted variation? Well, the government has said it will be three things at least, which are variations relating to pay and performance, working time and time off, so that could be holidays, and variation clauses. So trying to introduce a new clause into a contract that gives you some form of right to vary it again in future. So that might be introducing a clause that allows you to change a place of work, for example. We're awaiting regulations on this to clarify those three areas, and there's power within that for the government to set out additional areas that will cover as restricted variations, but also set out areas that might be excluded. So, for example, on pay and performance, there's a possibility that certain expenses might be excluded from being a restricted variation. The other piece to dig into a little bit is replacing someone with a non-employee. So it will be automatically unfair if that non-employee is doing the same or substantially the same activities as your dismissed employee, and that is not wholly or mainly due to business needs ceasing or diminishing. So similar to a redundancy situation. Those two tests are going to be quite key as and when you are dismissing an employee and bringing in maybe a self-employed consultant to do some or all of those tasks. It could also change in status of the same person. So an employee being dismissed, but then being re-engaged on a self-employed basis. There is a very limited exception to these sort of auto unfair rules, which relates to financial difficulties, but it is an onerous test to make out. So you have to establish that these changes that you're implementing are going to eliminate or significantly reduce the effect of financial difficulties. Those financial difficulties have to be at the time of termination or in the immediate future. It can't be we've got potential problems, 2 years down the line. That's not going to cut it. And it has to be sufficiently serious that those financial difficulties are affecting your ability to continue as a going concern, i.e. we might go out of business if we don't do this. And then you have a final element, which is that you could not reasonably avoid the necessity, which is likely to look at, are there other ways you could have avoided this other than making these changes to employment contracts? It's going to be pretty difficult to make out that exception, except in circumstances of genuine financial distress, where you are making changes that are designed to rescue a business. The other thing to bear in mind is even if you do make out that exception, all that means is that those dismissals are not automatically unfair. You will still have to ensure that they are fair dismissals following the normal rules. So we are awaiting regulations from the government, but what they're going to set out in there is certain things that tribunals will have to consider on normal unfair dismissal cases, which will probably include the extent of the consultation that's been done with the individual and with any representative, anything that you've offered sort of in exchange for the change, and anything else they put in the regulations. Other things to note, this doesn't necessarily stop variation clauses in contracts being valid. So for example, if you have a clause in your contract that you issue to a new employee that gives some flexibility on, for example, location of work, that could still be valid. So what we would say is well-drafted contracts are going to be even more important going forward. Firstly, so you don't hopefully have to amend them at all in due course, but also that you build in some flexibility. It's not that easy to do that, but you build in some where is possible to avoid these issues about changes in terms coming up in future. Final thing to flag on here, which is, I guess, a less foreseen impact of these changes, is that they may have an impact on reorganizations too. So it's not that uncommon for businesses to, for example, eliminate a particular role. Say this is a role we no longer required. However, we have created this new role over here, which you can apply for, and that role has some slightly different terms. Maybe it's a different salary or something of that nature. Now, it is possible that could be within scope and be automatically unfair under these regulations. You will probably need to establish that it is not the same or substantially the same duties between the role you're eliminating and the new role you are creating. So these need to be thought about not just when changing terms, but also when you're changing, for example, to a self-employed or non-employee model, and when you are carrying out certain reorganizations that are eliminating roles and creating others. Give you a few key action points just before we slightly move away from sort of dismissals. A few things to think about for planning for those unfair dismissal changes, in particular from the 1st of January. Reviewing your recruitment practices, making sure you are getting the right people in the first place. And you're really going to need to ensure that on day one of employment, you've got complete clarity over what their role and expectations you have for them are, because you are going to be wanting to more closely monitor their performance during that probationary period. The reason being is that if you've got someone that you do not think is a good fit, it is going to be far easier to end their employment in their first 6 months of employment than it will do afterwards. Previously, you've had the luxury of 2 years qualifying period for unfair dismissal, which you won't have obviously going forward. Have a think about your probationary periods and their length. Obviously, I've talked a lot about people getting the right at 6 months. In reality, if you are doing terminations without notice, with a payment in lieu of notice, they will normally be able to take into account the statutory notice period when assessing how long their length of service is. So you have to take off 1 week from that 6 months from that. So roughly 5 months and 3 weeks, a number of employees will be getting the right of unfair dismissal. Also think about, you've got to make a decision in good time before they tick over that 6-month period. So think about potential periods of sickness, think about potential manager absences. I would suggest that if you are looking to terminate an employee before the end of their probationary period, you're going to need to make a call on it a fair period of time in advance of the 6 months, maybe 5 months in at the latest. Look at your notice periods, particularly senior execs. Sometimes they have very long notice periods, and that has been partly due to the limited protection they get in law for unfair dismissal. That's going to change. So are those notice periods still appropriate? They might be, because you might say it will take that long to replace them, but something to think about. Tracking length of service is obviously going to be important to know whether or not you need to follow a full process or not. having your performance processes ready, because even with all the steps I've suggested, no doubt there will be some employees that you will retain beyond the 6-month period, but are still not performing to the standard required. You've got a potentially wider group of employees where you're going to have to follow formal processes, management training, and then a little bit of a harsh final bullet point. But obviously, if the cap on unfair dismissal is lifted on the 1st of January, should you be reviewing any senior exits prior to that point, because it could materially change the value of their claims. Right. Moving on to something different, quick whistle through of some changes to various leave rights that are coming into effect, most of these in 2026. Statutory sick pay from April of this year. There will be no waiting days anymore. So previously you only sort of got it on the 4th day. That won't be the case. First day of incapacity, you could qualify for statutory sick pay. And the lower earnings limit that meant certain low paid employees didn't qualify for it at all is being essentially removed, and instead you've got this weekly rate of pay, which is either the set statutory rate or 80% of earnings, whichever is the less. That will have very little impact for some employers, but others with low paid or irregular sort of hours staff, that could have quite a significant financial impact. Paternity leave becomes a day one right from April. There's still a 26-week qualifying period for the pay element. And you should also be aware that some regulations have been introduced in January for bereaved partner paternity leave, which most commonly will apply when the mother unfortunately passes during childbirth, which would give enhanced paternity rights to the father. But there are other scenarios as well that could be covered. That again is expected in April. We're waiting for those regulations to be passed. Parental leave, which previously you needed unpaid parental leave. This is, I should say, not shared parental leave. Sometimes it can get confusing, but unpaid parental leave becomes a day one right. Previously you needed a year's service. And then we have plans for bereavement leave, most likely in 2027, to allow at least 1 week's unpaid leave when there is a pre-24-week pregnancy loss or a loss of other relationships likely to be close relatives. We await the details of that, but it won't impact upon parental bereavement leave and pay, which is already in force. So yeah, this will be in addition to that. Another change that's due in 2027, which is in relation to flexible working. The current position is employees can make a formal request for flexible working, and if an employer wants to turn that down, there are 8 statutory grounds they can rely on to do so, including things such as detrimental impact on quality, impact on performance, inability to manage work amongst other members of staff. That's not changing, but from 2027, an additional element is due to be introduced, which is a reasonableness test. So you will only be able to turn down these requests on those statutory grounds if it is reasonable to do so. You're also going to have to state the grounds for the refusal, explain why it was reasonable to refuse, and we've got regulations due to be passed that will set out the steps that are required before you get to that outcome. The compensation for this is due to be unchanged, but you should also be aware that if you fail to get this right, you may not just face a complaint about failure to comply with the flexible working regs. You might also face discrimination claims or constructive unfair dismissal claims. So important to get right and await the regulations that should come out this year. So here's a big one that is coming in October 2026. So as many of you will be aware, from October 2024, all employers have been under an obligation to take reasonable steps to prevent sexual harassment in the workplace. That's going to change from October. That test or that requirement is going to change to all reasonable steps. And also there's the risk of being liable for third-party harassment, in relation to all protected characteristics. So all those different forms of protected characteristics, whether it's age, race, sex, disability, sexual orientation, etc., not just sexual harassment. It's going to apply if that third-party harassment occurs in the course of employment. So obviously, if there is a third party harassing your employee entirely outside the workplace, you can't be liable for that. But third party is likely to be given a wide meaning, so it could include anyone other than the employer or sort of fellow employees. So clients, suppliers, visitors, customers, etc. That all reasonable steps defence is going to be very onerous. It's going to be very difficult to reach that. This is due in force October of this year, but the regulations are currently only due in 2027, which obviously isn't ideal. But I would encourage all employers to be as ready as you can for October. The other thing to just mention here is from April this year, it is going to be made clear that sexual harassment disclosures in the public interest can also qualify as whistleblowing, which may make it increasingly difficult. There's already challenges with it anyway, in having confidentiality clauses that seek to restrict someone's ability to make such disclosures. Which leads me nicely on to some additional changes that are due on sort of NDAs, non-disclosure agreements. Timing on this is a bit unclear. This was a relatively late addition to the Employment Rights Act. So it could be this year, it could be 2027. But this is taking that change, that sort of whistleblowing change, and enhancing it even further. So what it is essentially planning is that confidentiality clauses will be void, so unenforceable, if they prevent disclosures relating to relevant harassment or discrimination or the employer's response to such allegations. So harassment or discrimination will be relevant if the victim or the perpetrator is a worker of the employer. And you should be aware that the employer's response meaning is broad. So essentially, confidentiality clause is going to be void if they sort of prevent someone making that allegation of harassment. But it'll also be void if it stops them talking about your response to that allegation. So, for example, if there was an allegation that you inadequately investigated it, that you brushed it under the carpet, that you unfairly performance managed someone because they'd raised such affairs, all of those things are likely to fall within the meaning of employer's response, meaning you won't be able to have a confidentiality clause that stops the employee talking about them. There are likely to be some exceptions. Again, we're waiting regulations to see exactly what they are. It could, for example, be circumstances where the employee themselves has requested the clause, and they've had independent legal advice on it, but we have to wait and see exactly what that might be. These is also likely to extend to contractors and people potentially on work experience. And the key step here ultimately is once we've got the detail of these regulations, in fact, I would encourage you to do it now anyway, is you're going to have to be very careful, in particular with employment contracts and settlement agreements, that your confidentiality clauses are not going to be void and unenforceable for restricting people in a way that will no longer be lawful. Quick whistle-stop run through of some other discrimination changes that are due. Most of these have a particular impact on larger employers. So if you've got 250 plus employees, you will be doing gender pay gap reporting. You will, going forward, have to publish equality action plans. So that will be covering things such as your gender pay gap and how you're trying to reduce it, how you're supporting people going through the menopause, and how you're seeking to prevent sexual harassment. It's not likely to be a requirement to do it more than every 12 months, voluntary from spring of this year, mandatory in spring from next year. Gender pay gap reporting, I mentioned it already, it's likely to be extended to duties to include outsourced workforces as well. Timing of that is a little uncertain at the moment as it's linked into some of the other government reforms. but that obligation is likely to expand out as well beyond your direct employees. And then you've got the draft Equality, Race and Disability Bill. Time on this unsure, depends how quickly it will progress through Parliament, but maybe 2027. And you're looking at ethnicity and disability pay reporting for large employers. New claims or new rights to bring claims for equal pay for ethnicities and disabled people, and the possibility of bringing discrimination claims based on more than one protected characteristic. So before we change the topic slightly, I want to just highlight again those changes to harassment in harassment law in October and things that you need to be thinking about and doing now. I would encourage you to apply your mind to this sooner rather than later. If you've got risk assessments in place that you already carried out for the sexual harassment changes in 2024, now is the time to dust those off and enhance them. You've got to cover your enhanced obligations, and you've also got to cover the fact that we are now looking at harassment on all grounds. As part of that, you're probably going to need to audit your third-party relationships. Who are your employees and workers coming into contact with? You know, that some of that will be obvious, physical contact, but also just think about, remote communications, Teams calls, phone calls, emails. You know, harassment isn't always in person. Updating your policies, having updated and fresh training programs. You might also want to think about other ways you're going to try and ensure your policies are effective. Are you going to have an anonymous reporting line? I would recommend that you have a centralized register of complaints, even for those that are sort of informal complaints that you're unable to take further, maybe due to further action, because it will help you identify trends. Can you offer further victim support? How are you going to foster a positive culture? What can you do to show that you're committed to preventing harassment from the top down, so directors having a real commitment to it? How are you going to monitor effectiveness of it? Obviously, you can review your policies periodically, but are you going to do employee surveys on awareness of policies? Do they feel safe in the workplace? And then also think about, as I've mentioned already, those employment contracts and settlement agreements have got to be proportionate and not excluding things from a confidentiality perspective that will no longer be lawful. Right, change of focus, looking a little bit further ahead, because this probably isn't due until 2027. And unfortunately, this is an area where we really do need some regulations to understand the scope and effect of these changes. But we've got some changes to 0 or low hour contracts to highlight. And essentially, there's going to be a new duty to offer guaranteed hours to 0 hour workers, so those workers who have no guaranteed work, and low hour workers who work in excess of the hours they're contracted for. What is a low hour worker? Well, we wait to see. But obviously, the part of this is about sort of anti-avoidance. If this only applied to 0 hours workers, employers might just guarantee 1 hour of work a week to get around the regulations. So that's, I think, part of the government's rationale as to why they're extending it out to low hour workers as well. We've also had clarity that this is also going to cover agency workers, and that obligation, that duty to offer guaranteed hours, is going to sit with the end hirer, so the person utilising the services. There's going to be a need to give notice of rights to those individuals who are likely to be covered by the regulations, and then at the end of every reference period, which currently looks like it might be 12 weeks, there's going to need to make this offer of guaranteed hours. The offer has to reflect the hours that have been worked in that previous reference period. The terms can't be less favourable than the worker has enjoyed to date. And the default is that it would be an offer of a permanent contract. It looks like we're going to have an exception for temporary work, but you'd have to make out that that exception applies if you're offering, for example, a fixed term contract. And then there's going to be various different rights, as I've sort of set out, for the employees or workers to enforce and be protected from detriment and dismissal as a result of these regulations. So a linked change is some changes relating to shift workers. So there's going to be 3 new shift worker rights, again, probably not until 2027. And they are a right to have reasonable notice of shifts, a right for reasonable notice of changes or cancellation of shifts, and then a right to payments for cancelled or curtailed shifts if that is done at short notice, unless there are specified circumstances. So these rights are going to apply to the 0 and low hour workers I've already talked about, but they could also apply to a wider group of shift workers, so anyone with a variable pattern. The only thing I would say is the focus of this does appear to be on the lower paid or the more less secure workers. And therefore there is some speculation that there might be a maximum salary or a maximum sort of hours limit, so that it is focused on those who are sort of at the less secure in their working pattern. And it also is going to apply to agency workers, save for excluded shifts. We wait to see what that means. And again, that payment for cancelled curtail shifts, we're awaiting details at the time of recording, but the likelihood is it is going to depend on the shift value. So how much were they going to get paid for it, and then how much notice is being given, and then potentially on a sliding scale down from full value down to, I guess, circumstances in which sufficient notice have been given and no payment is due. But we do await regulations. Right, changing topic slightly to deal with trade unions briefly. There are some changes coming in particular in October of this year, that will impact all employers, even if they do not have a sort of unionized workforce, or they do not have obligations to undertake collective bargaining. So that's the first 2 things on my slide there. So from October of this year, you are going to have to issue to all new employees before they start work a statement of trade union rights. We will have details before it comes into force of exactly what that will be, but it will likely be things such as their right to join a trade union and their protections from detriment and dismissal if they choose to do so. So that is going to have to form part of your, well, not even onboarding, before you get to that stage when you're issuing your contracts before start, that's going to have to form part of those processes as well. Also from October, unions are going to have a right for access to workplaces. That could be a physical access. It could also be sort of communications type access. So potentially the ability to send emails or intranet access. And that is for the purposes of to meeting, recruiting and organizing workers. So again, if you are an employer who is not particularly unionized, you're going to have to get used to the possibility that as and when a union gets in touch with you about these things, you're going to have an obligation to do something about it. We then got some changes which are sort of set out on the slide, which is changing to the process and the requirements for a union to request or apply for collective bargaining. So collective bargaining, again, in simple terms, just for the sake of what we're talking about here, that is where they have the right to negotiate collectively on behalf of their members in respect of things such as pay, hours of work, holiday. Employers and unions can agree that voluntarily. If they don't agree it voluntarily, then a union can make an application to what's called the CAC for that formal recognition. Now, as things currently stand, for them to make that application, they have to prove that they have at least 10% of the relevant employees are union members, and they have to demonstrate that there is likely to be majority support for that recognition. That majority support requirement is going to fall away, and that threshold of union membership is going to reduce to a number between 2 and 10%. It's currently at 10%. We don't know exactly the number, but it's going to reduce down. So easier to make those applications. And then once those applications are made, eventually it gets to a stage where there is a ballot of the workforce to see if they approve of the union being recognised. Currently, there is a minimum turnout figure for that ballot to essentially be valid, and that's going to fall away, and it will just instead be a simple majority of those who vote, are they in favour of union recognition for collective bargaining. Final thing I would just flag on here is that as and when these applications come in, the employer will have a very limited period of time to provide certain information about the workforce. 5 working days. If you are anticipating a union potentially making such an application, I would recommend you seek legal advice ASAP. Couple other things to quickly mention. When you recognise a union, from October 2026, there's going to be some enhanced rights to facilities and paid time off for trade union officials, learning representatives, access to facilities, and paid time off and facilities for trade union equality officers. And then I've mentioned on the slide there, I'm not going to go into great detail, because it's quite a specialist topic and doesn't impact too many employers, is the requirements for industrial action are essentially going to be loosened as well. So there were some changes to sort of the minimum service levels for public sector sort of essential services actually last year. And then we've got some changes going forward that essentially will reduce the requirements for lawful industrial action to be taken. That is an area where I would recommend you take specific legal advice if you are anticipating any such action. Right, another one that's coming in this year, although we do still wait some details on it, but as most of you are hopefully aware, there is an obligation on employers to undertake right to work checks to make sure that the employed workforce have the right to work in the UK. And there are some pretty stringent penalties, which I've set out on the slide, if you fail to do so, and can go through to criminal conduct if you know or have reasonable cause to believe that someone doesn't have the right to work in the UK. Well, these obligations are due to be extended this year to make sure that you are checking all of your workers. So that would include your sort of 0-hour casual workers, if you have any of those. I would suggest that it may well have been wise to have been checking them before now anyway, but there'll be a specific extension to them. But it's also likely to apply to individual subcontractors, so self-employed individuals and individuals engaged by online matching services. Now, it's not a dating service. As I understand it, it will be the type of business, for example, where there is matching up service providers with a customer. So it might be something where there is a sort of trade platform that connects, for example, an individual who needs plumbing services, and there may be an obligation on those matching services to undertake right to work checks on those professionals. We await further details of this. We await exact deadlines, but it is likely this year. So that's definitely one to watch, particularly in light of the penalties. Quick note on enforcement. Tribunal time limits generally for most things are 3 months. Currently, there are some that are 6, but from October 2026, the time limit for issuing tribunal claims will be extended to 6 months, save for breach of contract claims, which will stay as 3 months. Anything really to note on this is there's sort of a cumulative effect of this in a way. And the ACAS early conciliation period was extended last year from 6 weeks to 12 weeks. And we do have a backlog, which is more serious in some tribunals than others, in terms of just acknowledging claim forms and getting copies sent out to the employer. It's meant to be done within 5 days. There have been reports in some tribunals recently of that taking 12 weeks. Obviously, if you add 6 months, 12 weeks, and 12 weeks together, you could have a very long period of time between the actual incident or maybe the dismissal and getting formal notice of an issued claim. Just something to be aware of as an employer. We've also got a new enforcement body, the Fair Work Agency, due to come into effect likely April 2026, although some of its sort of new powers, not sure if they will have all of those day one, combining various enforcement functions, including the ability to undertake investigation, penalties for underpayments, and they can bring proceedings on behalf of an employee if there is wrongdoing. Just one to be aware of in terms of the potential enforcement of employment rights. Right, coming towards the end, a few final things just to run through. Changes to umbrella companies. So if you are familiar with them, the legitimate use of an umbrella company is they employ individuals, make sure their tax, national insurance is paid, make sure there's compliance with things such as pension and holiday obligations, and then they essentially have a contract with an employment agency or sometimes with an end client, but it's the umbrella company that employs them. From April 2026, the responsibility for those tax payments is going to shift, a bit similar to it did a number of years back and is still the case for off payroll, so the IR35 rules. Responsibility for those deductions will move up to the employment agency or to the end hirer if there's no agency in place. And the reason that is the government is concerned these umbrella companies are not properly accounting for tax and NI. And then from 2027, the plan is that they will be regulated in a similar way to an employment business. So that is in common parlance, sort of an employment agency. We've got a consultation ongoing at the moment on reform of non-compete clauses. So these are clauses that prevent an employee from working for a competitor after their employment has ended. Would wait the outcome of that. There has been speculation it could be a ban on them, or there could be a limit in time, or a limit in time that depends upon the size of the employer, but that's just one to watch. Public sector outsourcing changes. We've got some changes coming in October of this year that are designed to prevent two-tier workforce in most commonly private organisations that have taken on service from the public sector, so where it's been outsourced to them. There's already protection for the employees that might move across from the public body to the new private company. That is going to be enhanced to try and provide protections to those that are direct hires of the private company as well. Potential changes to public duties. We're expecting some confirmation details of that by the end of the year, including potentially acting as a special constable, falling within that sort of right to time off. Tips and gratuities. If this is important to you, you'll know all about it. If it isn't, you won't. Currently, there are obligations in place to ensure that you have a tips policy in place to make sure monies are passing through in an appropriate way to the staff that are working for you. There's going to be some additional obligations on that around consultation and review of those policies. The right to switch off seems to be on the back burner, essentially for the government. As many of you know, it wasn't in the Employment Rights Act. There's a lot of talk about there being a code of practice at some point in time. It doesn't appear to be progressing that quickly. And then salary sacrifice is some way away, but if you are an employer and you run your pension scheme through salary sacrifice, you need to be aware that from 2019, essentially that national insurance exemption is changing, which may have implications for how you run your pension scheme. So that's it. So it's been a whistle-stop tour. Hopefully you can appreciate it is only a summary of the various changes that are coming in. There's lots of areas where we are expecting further details to come out during the course of 2026. I would encourage you to subscribe to all our different updates and webinars, because we will be reporting on these throughout the year as things are confirmed. I also highlight on this slide, depending upon the time you're watching this, if you are in Reading on the 10th of March, we've got an in-person networking event with an external speaker, which will be great to see you there for that. And my colleague David Clay is also running a live webinar on the 17th of March on settlement agreements, when, why, and how. So he'll be answering all your questions there. But if you've got any questions on anything I've covered in this session, or indeed anything else, then don't hesitate to get in touch. You've got all my details there, and it would be lovely to hear from you. Thank you very much.